Mr. Chief Justice, and may it please the court. Respondent's argument that Officer Wilson would have known about Mr. Gribble's injuries rests upon a mountain of assumptions that shouldn't provide a stable enough foundation for you to base your second assumption that he was deliberately indifferent to the injury on. Again, as held in Chavez versus Katie, the attitude toward the detainee must satisfy the second prong of the test, the deliberate indifference. The respondent has simply not shown enough evidence to prove for you to adequately infer that Officer Wilson was indeed deliberately indifferent to the injury suffered by Mr. Gribble. The injury that they want you to focus on, the stroke and whatnot, simply wasn't evidenced at the park in a manner that Officer Wilson would have known to react to it, and in a manner that proves any of his reactions was deliberately indifferent. Furthermore, their other argument rests on the fact that Occupy Garner was not allowed to recreationally do camping. However, nothing in the statute says that recreational purposes have to be the primary purpose. Additionally, as your honors pointed out, who defines recreational in today's case? I certainly don't think that Occupy Garner was
well, doesn't the
camping
city define it? Isn't that the point?
Your
that
Honor,
you have a ambiguous term that's subject to interpretation. The city will interpret what recreational camping is or is not, and that's the problem constitutionally for your ordinance from a vagueness standpoint.
Your Honor, I think it's clear on face because it's not skewed towards one thing or another. If anything, you'd have to look at how it was applied, which goes beyond the scope of the facial challenge before you today. Hill, Ward, and Heffron all show extreme deference to the local government. The city of Shawnee was well within their rights. Thank you.
Thank you, counsel, and thank you all, counsel.